Welcome to Aging Insight with your host, John Ross and Lisa Scholmeyer. This program is made possible by
Welcome back, everyone, to another edition of Aging Insight. I'm Lisa Scholmeyer, and I'm here with John Ross, and we are elder law attorneys, which means that we focus on meeting the needs of seniors, families that have seniors, and people who might be a senior someday. So I think that pretty much covers the gamut there.
Yeah, lots of times people will say, well, John, how old do I need to be to see an elder law attorney? And the answer is 18.
Right. So, but we have put our resources and time into bringing you Aging Insight because we know how important it is for you to be educated and have information. And so, it's great to be able to bring this television program right into your living room so you can watch and learn from us, because we want you to have the answers and the knowledge about things like remaining independent as long as possible, and hopefully making sure you have the resources in place to do so, to try to avoid being a burden on friends and family, and to not go broke in the process. Aging Insight is here to help you with all of that.
Yeah, and we combine lots of different areas of the law in order to bring this stuff together. We talk about government benefit programs like Social Security, Medicare, Medicaid, veterans benefits. We've talked about things like powers of attorney and guardianship, and we've talked about how taxes and real estate and all of these different things start coalescing into one unit of stuff that you've got to be thinking about. And oftentimes I find that those are the most important things that people need to think about, are the stuff that matters to them now while they're alive.
Right.
And yet, I would say that more often when people are coming in to ask me questions, they're asking me questions about things about what's going to happen after somebody dies.
Right.
And I get it. We know that's going to happen for sure.
That's right, 100%, every single one of us.
There's nobody out there that's denying that is going to happen to them. So often they are in fact denying that they're ever going to need additional care as they get older, that they might become incapacitated long before they ever pass away, that they may make bad financial decisions because of their infirmities, that their family might fight amongst themselves, all kinds of things that they ignore.
Yeah, so we focus a lot on, while you're living, because, that's the information that you need, but we do get a lot of questions, particularly after someone has passed and they have left a last will. We often get family members coming in to visit and asking the key question of, do I have to probate this will?
Yeah, we get that all the time.
Yes.
I mean, really, that is a common question. We give a lot of speeches. We do our Eggs and Issues breakfast on the fourth Thursday of every month over at Trinity Church, and it seems like every other one or so, somebody in the audience will say, well, now, wait a second, I'm confused. Do I have to probate a will?
Yeah, because there's a lot of misinformation and rumors out there about probating a will. So, in order to answer the question, do I have to probate a will? First, let's remember what probate is all about. When someone dies and they have executed a last will and testament, then that will is just a piece of paper that's written down. That's all it is, even at the death of that person. In order for that document to be legally effective, we have to offer the will for probate. And all probate is the name of a process that happens at the courthouse. So a will becomes effective at, number one, the testator or the person who made the will must be deceased. And number two, that will has to be offered to the court through an application or a pleading process to the court that says, hey, court, will you look at this will and determine if it's legal and valid, and if so, admit this will to probate. In that case, we file the pleadings, the judge looks at the will, we have a little hearing, and if everything is in order, the judge admits the will to probate. And you know, John, that probate process really does two things. You know, first and foremost, a probate process protects creditors and gives creditors of the deceased an opportunity to come in and file their claims and get paid.
Right.
That's the first thing that probate does. But the second thing, and what's typically important to the family, the second thing that probate does is deliver the assets and clear the assets down to that next generation, to the beneficiaries of the will, with a clear title, real estate, vehicles, things like that. But you know, probate, when I said go to the courthouse, you know, people, you know, we always say the minute you have to go to the courthouse, it costs some money.
Right. Yeah, you've lost as soon as you walk in the front door of the courthouse.
And so I think, you know, a lot of folks ask, do I have to probate the will? Because if they have any understanding of what that means, they do know that's a court proceeding, and they're concerned about the cost of that probate. And oftentimes they've heard that many times probate is unnecessary, or that the assets will automatically go to somebody or somebody else, and they don't have to actually probate the will. So that's where that question comes from.
Yeah, it does. And this may sound, you know, when it talks about probate, you know, yeah, you've got court costs. You also, as part of that probate process, you have to notify the creditors. You do that by publishing notice in a newspaper, and you'd be amazed at how much those newspapers charge for that little block in the paper that says, you know, hey, if this guy owes you any money, now's the time to file a claim. So there are some of those costs, but one of the biggest costs in the whole process is attorney's fees.
Right.
And this may sound a little strange, but unlike almost any other type of case out there, you cannot represent yourself in probate. And that's because you're not representing yourself. If I am the executor under somebody's will, that executor is in charge of managing it for everybody.
Right.
Not just for themselves,
right,
but for all the beneficiaries. And if you are in a courtroom and you're acting on behalf of other people and you don't have a law license, that's the unauthorized practice of law, and you're going to go to jail. So you've got to have an attorney that assists with this, which just increases the costs. And I didn't make that rule. Don't blame me.
Right.
Don't,
yeah, you didn't lobby your representative about that.
No, it has nothing to do with us. So, but we're going to keep talking about some of this because, again, you know, so many people will say, yeah, but I didn't probate my daddy's will or my mama's will or my husband's will. And maybe you're right.
Yeah, maybe so.
And maybe you're wrong. So stick around, we'll keep talking about this. We'll be right back.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana. And there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight. I'm John Ross here with Lisa Scholmeyer, and today we're answering the question, do I have to probate that will? We get that all the time.
Yes, all the time. And, you know, we always give the lawyer answer initially, which is, it depends.
It depends. You know, and we talked about, the first section, we talked about the law is very clear that no will is valid unless it has been probated. Now, that term probate can mean lots of different things. There are simplified probate procedures in most states, what they call small estate administrations or muniments of title, and all kinds of funny legal names that are simplified probate processes. But ultimately, you know, you've heard that wills have to be signed, and they have to be witnessed, and they have to have notaries, and all these different requirements that goes into making a valid will. Well, there wouldn't be any point in having all those requirements if somebody didn't check to make sure all those requirements were followed. And that person who checks is the judge. That's the probate. It's making that will official and making the terms of that will be carried out by the executor. And no will is valid in any state in the United States until it has been probated. That rule is in Texas, it's in Arkansas, and it's in everywhere else. No will is valid unless it's been probated. But this doesn't answer the question. And that's probably because you're framing the question incorrectly. You know, oftentimes people will say, does a will have to be probated to be valid? Well, we've already answered that. The question is yes. What they're really asking is there a necessity to probate that will? In other words, is there some reason why I need to go through that whole process? And that is a completely different question. From the simplest standpoint of, let's say that I am a hobo. I'm living on the streets. I own absolutely nothing. I have no possessions, no money, no assets, nothing, and I draft up a will, and my will says I leave all my worldly possessions to Lisa Scholmeyer, and then I die. Well, if I don't own anything, is there any point? Is there a necessity to probating my will? Of course not.
Right.
If I don't own anything, if there's nothing for that will to transfer, then there's no reason why you would go through that process. Is my will valid until it's probated? No. That will is just a blank piece, it's just a piece of paper, and it's worth nothing more than a used piece of paper is worth. But you wouldn't pay the money, you wouldn't hire a lawyer, you wouldn't pay the court costs because there's no assets to transfer.
But, you know, I think when it comes to, is there a necessity to probate? There's one situation that I always answer that question as yes. And that situation has to do when we are involved with a deceased person who was a second or more marriage situation where they had children from a first marriage or a previous marriage. And I think my rule is about 100% of the time, if you're in that situation, if you're the widow or widower and you know your now deceased spouse had a marriage before you and a family before you, you know, in that situation, almost 100% of the time I'm saying it is necessary to probate that will. And there's some real valid reasons here. A lot of times I'll have that widow come to me and say, well, but my husband, we've been married for 25 years, even though he had been married before me and had some children, but we've been married for such a long time. You know, I think everything we have, we've gotten together. You know, the kids, we have a great relationship. That's not an issue. So do I have to probate the will? Is it necessary to probate the will if my husband left everything to me? And you know, John, I'm going to say yes.
Yeah, and oftentimes it may not be. You know, we got to kind of understand that if that husband and wife had a joint bank account, 9 times out of 10, the bank account contract is going to control, and that bank account contract is going to say whatever is in that account belongs to the surviving joint owner. If you live in Arkansas and a husband and wife own a piece of real estate that's in both of their names,
as husband and wife,
yes, then it will belong to the survivor. But there are still other cases where things would not necessarily pass down to that survivor, and there could be assets that you are unaware of out there, assets that could crop up later. You know, for example, I talked to somebody recently, and their father had died, and about 2 years after his death, they got a letter from a law firm who the dad had reached out to while he was still alive, because he had developed some breathing problems. He thought it might have been from asbestos. He ended up dying of those breathing problems, and now the law firm, 2 years after his death, is ready to take up this case, and there will be proceeds from that, and those proceeds, they're not in a joint bank account.
Right. It's a new asset.
That's a new asset. And I've experienced this even with my own family, where we discovered assets that were inherited assets that my grandfather didn't even know he owned. Mineral rights in far off counties that he didn't know he owned because they weren't producing. And then when somebody finally found some oil or gas on them, sure enough, they tracked down the family.
Yeah. But John, so often in these situations with second marriages and beyond, people look at the expense of the probate and they really want to try to avoid that. But the problem is, in both Arkansas and Texas, those children from that first earlier marriage and relationship, they have certain property rights that if a will is never brought to the court for probate, then those children's rights take precedence over the wishes of the deceased, because if we never probate the will, then the wishes of the deceased are never officially recognized by the court. So, if we have that situation where the deceased has left real estate or, other assets that only had their name on it to their spouse, we better probate that will to make sure that those spouses' rights are protected. Otherwise, the kids can come in later and say, hey, wait a minute, we own this house, or, we own this asset. So to protect that surviving spouse of that second or longer marriage situation, we really need to probate that will.
Right, and you're talking about in a second marriage. I'd just take it a step further, because if you look at the Arkansas law, in Arkansas, if you die without a will, your stuff goes to your kids, not to your spouse. Yeah. In Texas, if it's community property and all of your children are children of the marriage, then your community property passes to your spouse. But even if it's not a second marriage, if you had property that you had prior to marriage, that does not go to the surviving spouse, at least not 100%, even on the Texas side. Okay. So you've got all of these different laws out there that say who gets your stuff in the event you don't have a will. And that's the problem. If you don't probate that will, you don't have a will.
Yeah, it's like you never had one.
That's right. And if you don't probate, and there's time frames on this. So we're going to take a break, and when we come back, we'll kind of talk about what those time frames are and when you don't have to worry about it. So stick around. We'll be right back.
As things get older, they require more care. This car and I have seen a lot of miles together, but because I take care of her, she runs just like she did in 1955. That's why I chose the Wadley Senior Clinic, with an individualized care plan designed just for me and a convenient location off Jefferson Avenue. They have everything to keep me running like new. It's not about the miles, it's about the journey. Let the Wadley Senior Clinic keep you happy, healthy, and cruising down the road of life.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
Welcome back to Aging Insight. I'm Lisa Scholmeyer here with John Ross, and today we're talking about a very common question we get after someone passes, and that question is, do I have to probate the will? John, statistically, you know, just a small percentage of people actually have wills in place.
Yeah, about 70% of people die without a will, I think, in this country.
And so, but you know, a lot of folks that have taken care of their business, and you know, sometimes older folks, they make sure their younger generation, their children, know where their documents are, that they've taken care of that there's a will, where they are. You know, that's a good situation. But you know, after that death of that loved one, what's next? And so that question is, do we have to probate that will? And you know, we've talked about the situation where in second marriage situations, the answer is, you know, yes. In Arkansas, where there's any children, whether it's a prior marriage or the current one, you know, they have rights that if the will's not probated, they can assert. But you know, we talked about timelines, that if you don't bring a will and have it and offer it for probate to the court, then you've only got a limited amount of time to do that. And after that time expires, it doesn't matter how official that will looks or that you still have it. It's too late. So what are those timelines?
Yeah, you know, almost everything in law has a statute of limitations. If I rear end somebody in my vehicle, they have a right to sue me for the damages, but they've got to file that lawsuit within a certain time frame. And if they don't file it within that time frame, they lose their rights to sue me. That's called a statute of limitations. Wills have their own statute of limitations. In Texas, for example, you have 4 years from the date the person died in order to probate that will. If you do not probate the will within that 4 years, the will is invalid. It is no longer, it's as if that person died intestate, meaning without a will. Arkansas gives you an extra year. So in Arkansas, you have 5 years. But the same thing, if you don't probate that will within the 5 years, then the will is invalid completely and forever.
Yeah.
And so that's, you know, so for these folks that say, oh, well, there's no need for me to, there's no necessity for me to incur the expense and time of probating that will, what you've got to understand is you better be really, really sure of that. Because if that turns out to be wrong and enough time has passed, you'll never be able to go back and fix it.
That's right. You know, when I had that situation come up, John, I had a client who, he had 2 children, and at his death, in his will, he left everything he owned to one of those 2 children. Now, after his death, the 2 children went to the lawyer and said, do we need to probate the will? And the lawyer said, well, you know, if you guys are talking about sharing everything anyway, then no, we don't have to do that. Well, you know, what was unsaid was the child who was awarded everything in the will, if she just sits around for 4 years, then she loses the right to all of those assets.
Right.
And so we did catch it within a couple of years, and we did go on and probate the will. But you know, there was a situation right there.
Yeah, and I've seen the same thing in a spousal situation where, you know, a surviving spouse had a will. The will said, you know, I get everything. She mistakenly thought that because the will said she got everything, she got everything.
Because that's what the will said.
Because that's what the will said.
Yeah.
Not realizing, again, as you've now learned, that will is not effective until it's been probated, and she didn't probate it. And 4 years later, a little over 4 years later, her children filed for probate, claiming that he died without a will. She still had the will, showed it, it was prepared by a lawyer, and then it was signed and witnessed and notarized, and it met every definition of a valid will except for one, and that one was that it had not been probated during the 4 years after that person had died, and as a result, the spouse was treated as having died without a will, and therefore state law took over.
Right.
And in this case, because it was a second marriage, like you indicated before, the children of the deceased ended up obtaining a share of the estate.
Right.
And all those rights came in. And this can be even more particular in some of the other locations, like Louisiana, for example, and you know, you've got different laws in different states, and so you're going to want to be, if you think that there is no necessity to probate that will, that may be true. You don't have to probate a will in every single case.
No, you don't. And there are circumstances where you can do very abbreviated probates that are much less costly, or like you say, there are certain circumstances where no probate is necessary at all. But as a layperson, I guarantee you are not knowledgeable enough to determine that. So, you know, it usually doesn't take much. Just call up a lawyer and see.
But I would say get somebody who is very experienced in the probate process. Probate law is different than almost every other type of law out there. It's a completely different set of rules from divorces and car wrecks and things like that. And oftentimes what somebody thinks about property rights because of their experience as a family law attorney are completely different than what they are as a probate attorney. So find somebody that knows what they're talking about and be 100% sure before you decide that you don't have to probate that will, because a small investment in something like one of these simplified procedures, if something does come up later, you'd be awfully happy you did it. And since you can't ever go back, you know, there's a cost to some surety and confidence out there. So anyway, hope you learned a little bit of something now on all of this. It's a good lawyer answer, maybe.
That's right, it depends. Yes.
But if you want more information, or if you've got unanswered questions, give us a call some Saturday. We're on the radio live on 98.5 every Saturday, where you can call in and ask questions. You can rewatch this episode and others on our website, aginginsight.com, and also listen to the back episodes of the radio program. Pick up a copy of our Aging Insight magazine. Lots of good information about most of these topics. But of course, you can always just keep watching Aging Insight right here on KLFI.
Yeah, great. So we look forward to seeing you next week on another episode of Aging Insight.
We'll see you later. Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Scholmeyer. This program is made possible by